What is the process for enforcing trademark rights? Well, generally, it depends on the level of protection that an individual has. So you look first to the extent of your protection. If you have a federally filed, nationally protected trademark, then you have more options than if you just have common law or statutory protections in a state. But in some cases, depending on the availability or your ability to get into court, in some situations, it may be advantageous to you to pursue an action under state law. So, with that in mind, you'll either file an action in federal or state court based upon common law protections under state law, statutory protections under state law, or in federal court pursuant to your federally registered trademark. Okay. Now, before litigation generally begins, most of the time, the parties will send the party claiming trademark rights will send a cease and desist letter to the individual using the mark that supposedly infringes upon the trademark holder's rights. And after that, if the individual does not respond to the cease and desist letter with some means or method or plan for ceasing to use that mark in commerce, then again, the party can initiate the trademark action. The big advantage to initiating the action in federal court, if those protections are available, is the geographical boundary. It'll have precedent all throughout the United States. You can bring the action anywhere throughout the United States. And also, the federal action, the filing nature of the trademark creates a presumption for the holder of the trademark rights that they are valid. And that's something that the defendant, the individual infringing upon the trademark, would have to overcome in court. So again, this stacks the odds again in favor of the individual seeking to enforce the trademark rights. And then lastly, the individual filing the action, the holder of the trademark rights, may be able to recover court costs and attorney's fees for enforcing his or her trademark rights.